This is an AZ Court Help Legal Talk on court basics for friends and relatives raising children. Thank you.
Good afternoon. Thank you for joining us today. My name's Gretchen, and I'm the law librarian at the Coconino County Law Library. And the information that we're going to talk about today applies across the whole state of Arizona. Today, we're going to talk about the different options for a non-parent to get parental control over someone else's children. There's 4 main legal ways to do this: power of attorney, adoption, guardianship, and non-parent custody. And we're going to look at each of those. We're going to spend most of the time talking about guardianship and non-parent custody, but we're going to touch on the other 2 briefly. With a power of attorney, a parent shares their parental authority with you. The court is not involved. It doesn't get filed with the court. You just pick up the forms, and you can find forms at your law library in your county. And it lasts up to 6 months, but it can be renewed. The parent can keep renewing it every 6 months. It has to be signed in front of a notary. It's the parent who's going to sign it in front of a notary. And you can find a notary at most banks. Everybody signing has to have photo ID with them. And in addition to the parent and the notary, there also needs to be a witness. And that witness can be almost anybody, but it cannot be the person that you're giving the authority to, and it cannot be that person's spouse or child. But if you have another friend or family member who doesn't fall into one of those categories, that person could be the witness for you. Also, many banks will provide a witness. If you're wanting to use power of attorney so that somebody else can enroll your child in school, you'll want to check with the school to see what exactly are they going to require of you to allow that other person to enroll your child in school. Sometimes the school uses these terms a little bit differently than we do at the court. So when the school says power of attorney or the school says guardianship, it might mean something a little different to the school than it means if you were to go and ask your law library for one of those things. So when you check with the school on this, don't even use those terms. Don't use the term power of attorney. Don't use the word guardianship. What you really need to find out from the school is all you need from me a notarized statement giving authority to this other person, or do you require a court order? So if you can find out from the school, do they need a notarized statement? Is that sufficient? Or do they actually need a court order? Then if you can go to your law library with that information, they can connect you with the right things. The second way that we're going to briefly talk about to get parental control over someone else's child is adoption. Adoption completely and permanently terminates the parent's parental rights and transfers those rights to the adoptive parents. It cannot be revoked. It's permanent. If you're looking to do an adoption and nobody is going to object to the adoption, then the county attorney's office in your county probably has a free service to help walk you through the whole process. If you think someone is going to object, then you may find it helpful to start by speaking to an attorney to learn what's involved with an adoption. There's not self-help packets, not self-help fill-in-the-blank forms for adoption. So if no one objects, county attorney probably has a free service. Someone's going to object, maybe speak to an attorney to get started. So the rest of this presentation is going to be about numbers 3 and 4 of the ways to get this authority, and that's guardianship or non-parent custody. Both of these transfer their parental authority to you. So it, at least temporarily, takes the parental authority away from the parents and gives it to you. Only the court can give someone guardianship or non-parent custody. A parent doesn't have the authority to give you one of these powers. Only the court does. And either one of these could end before, either one of these is typically in place until the child turns 18. But if circumstances change, if a parent is in prison, for example, and when the child is 15, that parent is released from prison and is available to parent, and everybody wants that parent to take back over the parenting, you can go back to court, let the judge know circumstances have changed, and these could end before the child turns 18 in situations like that. So how do you decide between these two, guardianship or non-parent custody? They both go through the court. Well, what's the difference between them? One difference is that certain things have to be true in order to get one or the other of these authorities. And it's a little bit different what has to be true to get guardianship versus what has to be true to get non-parent custody. For guardianship, one of these two things has to be true for each parent. Either the parent agrees that you should be the guardian, or if they don't agree, if they won't sign an agreement to it, then you need to be able to convince the judge that that parent's rights should be suspended for some reason. So let's say maybe the parent one is going to sign an agreement, so that's fine. You've checked the box for that parent about one of these things being true, but parent two does not want you to be the guardian. So for parent two, you would have to be able to prove to the judge that that parent two, for some reason, should not be able to parent right now, and that their parental rights should be suspended. A couple of reasons why the judge might agree that a parent's right should be suspended is if they're deceased, if they are incarcerated, if they have abandoned the child for at least the last 6 months, if they can't be found, or there might be other circumstances that are unique to your situation that the judge would be convinced by, and you can always describe those in your own words on the forms. So that's what has to be true to get guardianship. Now for non-parent custody, it's a little bit different. 4 things all have to be true. Number 1, the parents should not have custody. You have to be able to convince the judge that that's true. And the child treats you as a parent. And there have been no court orders about this child in the past year, or the child is in danger. And number 4, 3 options. One of these has to be true for number 4. Either the parents are not married to each other, or the parents are married but they have filed for divorce, or one of the parents is deceased. So again, all 4 of these things, they shouldn't have custody. The child treats you as a parent. One of these things under number 3, one of these things under number 4. All of that has to be true for non-parent custody. So once you have reviewed these and decided which one of these best applies to your situation, then you can choose which of these options are you going to pursue. Now, another difference between guardianship and non-parent custody is how long they take. With guardianship, the overall case is going to take at least 2 months. So it is possible to get a same-day emergency order if there's an emergency situation. With non-parent custody, that overall case is going to take at least 1 month, and it could take quite a bit longer if somebody disagrees. If there's an emergency, the quickest you can possibly get non-parent custody is about 10 days. There is no same-day emergency order available with non-parent custody. Okay, so now you've decided based on what we just talked about, what has to be true to get it, how long does it take, what is your situation and your needs. You've decided whether you're asking for guardianship or non-parent custody. Let's look at a couple options under the guardianship category. Usually guardianship is going to be ordered until the child turns 18. Now, in limited circumstances, you can get a temporary guardianship that is going to last for a shorter period of time if there is just a short and specific length of time that you need this authority. If you know that you only need guardianship for less than 6 months and you know what date it should end on, then you can just ask for a temporary guardianship. And that process is a little bit easier than the regular guardianship. There's fewer forms and it's just a little bit easier. But you can only ask for that if these things are true. You know it's going to be less than 6 months and you know what date it's going to end on. If that is not the case, then your only option is the regular guardianship if you're asking for guardianship. Regular guardianship, there's no end date put on it. It's assumed it's going to be in place until the child turns 18. But like we talked about earlier, the judge can end it sooner if circumstances change. Anyone can come back to the court at any point to say these circumstances have changed and we need to end the guardianship before the child turns 18. If you're filing for guardianship, you are also going to see the word conservatorship in the court materials. So what's the difference between this guardianship and this conservatorship you're also going to see? Well, guardianship is basically parental authority, and conservatorship is basically financial authority. So if you need the court to also give you financial authority over the child, then you can also ask for conservatorship. And the court forms are going to give you the option to ask for guardianship, conservatorship, or both. And you'll just choose based on your situation which of these authorities you need. There's a lot of different reasons why someone might ask for conservatorship in addition to guardianship. One example is if, say, there was an accident and there was a settlement and there's a bank account that has a lot of money in it from that settlement for the child, holding it in that bank account until the child turns 18. That's a situation where a conservator would have the authority to manage that account. So one reason that you might ask for conservatorship is if the child has some sort of substantial or unusual assets. Okay, so now that you've decided which of them you're going to ask for, how do you ask for them? First, you're going to get your forms and instructions from your law library or the clerk of Superior Court in the county where you live, or from this website, azcourthelp.org. And this is a great website to have a bookmark on for the future as well. It has a lot of self-help legal information on every topic under the sun: landlord-tenant, probate and wills, divorce and custody, and also guardianship and non-parent custody. So if you have a bookmark on it, you can have it for future situations. You can share it with friends or family members who have legal situations. And typically, you're going to file these case types in the county where the child lives. Usually, the child is living with you in these cases, but not always. Wherever the child is living when you file this case, it's typically going to be that county in Arizona where you file this. For guardianship, there's a couple additional requirements in addition to filing forms, and one is to read an online training. When you go to the website that you'll find in your self-help materials, your forms and instructions, when you go to the website that provides for the training, you'll see these options. And if you are asking for guardianship, you need to take the guardianship training module. It's just something you click on, and it's a PowerPoint, and you read through it online. And it gives you a lot of detail about your rights and responsibilities as a guardian. If you're also asking for conservatorship, you also need to do this one, the conservatorship training module. And then another special requirement that applies to guardianships is that if you are not related by blood to the person, the child that you want guardianship of, you'll be required to have fingerprints taken and to file those with the court. You can usually do that at your local law enforcement office, but look at your self-help materials for your location to see if it gives you details about how to do that where you're filing. Once you have filled out the form, and if you're asking for guardianship, you've read the trainings and you've done the fingerprints if necessary, now you're ready to file those forms with the clerk of Superior Court in the county where you're filing. And when you file, some of those forms are going to have been signed by you in front of a notary. You'll need to have a certain number of copies, and you'll need to have your filing fee. So you'll need to know, in Yavapai County, how much is the filing fee? In Pima County, what form of payment do they accept? These little details are just a little different from county to county. So to avoid a hassle of maybe going to the court with a personal check only to find out then that they don't take personal checks, make sure to read your instructions carefully, and it should guide you on what has to be notarized, how many copies does this county require, what's the filing fee, and what form of payment do they accept. After you file the forms, the judge is going to schedule a court date. They're going to schedule a hearing. They're going to mail you a form letting you know what is the date and time of that court date. If it is a guardianship case, that form is going to be called probably a notice of hearing. If it's a non-parent custody case, you'll see this wording in the upper right of this screen. That might be called an order to appear, and it might have these words on it, in loco parentis. What in loco parentis means is in place of the parents. That's referring to how with non-parent custody, you're asking to be given the authority in place of the parents. So that's what that strange non-English words mean if you see that on your forms. Once you get that notice of hearing, now you are required to notify specific people that that hearing is going to happen. Who are these people? It's a little bit different for the two different case types. For a guardianship, you would need to notify the child if they are over 13 years old. You would have to notify a parent if they did not agree to the guardianship. And you would have to notify anyone other than yourself who currently has the main care or custody of that child. And then for non-parent custody, the only people you have to notify are the parents. So how do you notify these people? This screen is showing you one option, which is to have a sheriff or a process server hand deliver a copy of the paperwork to those people. But in fact, it's a little bit different what your options are, depending on whether you are asking for guardianship and conservatorship, or if you're just asking for guardianship. It's a little bit different if you're asking for non-parent custody. So read your instructions in your self-help material to see for your specific case and your specific situation, what are your options for giving these people this notice? Once you have given them the notice, you have to let the court know that you did that, because the court needs to know that these people who this situation and this court decision might affect have had an opportunity to review your requests and to let the court know if they have any input or objections on that. And your self-help material will let you know, how do I let the court know that I notified them? For example, if in your situation using the sheriff with one of your options, the sheriff will typically create a form saying that they gave it to the other person and here's how. And you would file that form with the court. So look at your self-help instructions to see how to let the court know you gave the forms to those people depending on which methods you use to give it. Then you're going to go to that hearing that you saw the judge schedule on the order to appear or the notice of hearing. And at this hearing, the judge will hear from you, review the situation. The judge will hear from any of those people that you notified if they decide that they would like to share any information at that hearing. And then typically at that hearing, the judge is going to make the decision about whether to give you the authority that you requested. After the hearing, the court will mail you the court orders. And what you're hoping those court orders say is you've got the authority. So let's say that it does say that. You're going to get the orders saying you're the guardian or you have non-parent custody. When you get those, read everything carefully. Especially with guardianship, there can be quite a number of pages. And that's because there are a lot of responsibilities and requirements associated with being a guardian. And you want to make sure that you understand all of those so that you don't accidentally fail to do something or do something wrong. So just set aside half an hour, get yourself a cup of tea, read through those carefully, and make sure you understand everything that the judge has ordered you to do and all of your obligations. And if you have questions after reading it, you can contact your law library for assistance. So if this is a non-parent custody case, that's the end of your case. You went to the hearing, the judge made the decision, you got the final court orders. You're done. You've got the authority. If you're a guardian, there's a couple additional things that apply now after that hearing. One of those many pages I said you're going to get in the mail after your hearing is going to be this form that is called letters. That's a strange and mysterious word to call a form, letters. But what that really means is this is a court order. This is a court order saying that you are the guardian and or the conservator, and it's signed by the judge. And you also have to sign the letters after you get them. That's you accepting the letters, accepting that responsibility and authority. So that's why this form is called the letters and the acceptance of the letters. And this is the document, the main document you want to have with you when you go to the doctor, when you go to the school. This is the main document you would show people to let them know that you have authority over this child. Another thing that applies to guardianship after that final court date is that you have to keep in touch with the court once a year to let the court know how the child's doing. You'll be filing what's called the annual report, or might be called the guardian's report. It's something that you file once a year, and it goes over what sort of social services might the child have received in that past year. Has the child's address changed? When's the last time they saw the doctor? Bunch of details like that, because the court has a legal responsibility to have oversight of the guardianship and make sure that the child is in good care. So your law library can provide you with forms and instructions for filing the annual report. And you know, all those pages that you read while drinking a cup of tea, those pages are going to tell you what is the date of the due date of the first annual report after your appointment. Make sure you find that in those pages and write that on your calendar and file that annual report by that time. And then after that first due date, it's going to be every year on that date after that until your guardianship ends. And sometimes the court will say, we're going to put the due date on the calendar, and nobody has to come to court, no one has to talk to the judge, as long as you file the guardian's report by a certain number of days before that due date. But if you fail to file it by that certain number of days before the due date, then you have to appear at court, and the judge will review the situation. So to save yourself hassle, just make sure you carefully read what you get from the court and note that deadline that gives you that opportunity to avoid having to go to court about the annual report, and merely file the document if you do it by that certain number of days before the due date. And so that is the end of your process. You are now the guardian or the non-parent custodian. And if you have any questions as you're going through the process, contact your law library. And otherwise, I thank you for joining us today.